left her bloodied.
How did she cut her arm, Mr. Simple? How did she cut her arm?
Daniel pushed me.
This is Judge Judy. Cherie Zarate is suing her ex-boyfriend, Daniel Seipel, for rent and utilities, property damage, and an assault.
Judge's case number 96 on the calendar in the matter of Zarate versus Seipel. Parties have been sworn in.
Thank you. Ms. Zarate, you and the defendant know each other, according to you, for well over a decade. And there was a time, according to you, that he was your boyfriend.
Yes, for sure.
When was he your boyfriend?
2007 to 2008.
Are you currently married?
No.
Who do you live with?
I live with myself, and I have a house tenant at the house that I'm at.
Is that your house?
Yes.
When did the defendant become incarcerated? In what year?
It was May of 2019 to August of 2019.
And after you were no longer involved with him romantically, did you maintain a friendship with him?
Yes.
Just friends or more than friends?
Just friends.
According to you, when the defendant, your brother, owned a house
Yes.
that another brother had lived in who recently passed away.
Yes.
And you and your brother, or you, made an agreement with the defendant that he could live in the house and pay either $400 a month or rehab the house because the house needed a lot of work because the house was in bad condition.
Right.
That's what she says. Just a second. And your lawsuit asks for $5,000 because you say he did not do anything in the house.
Right.
He did not do work in the house.
Right.
He did not pay rent.
Right.
And he assaulted you.
Yes.
That's what your case is about.
Yes.
Okay. Have I pretty well rounded out what your case is about?
Yes.
Yes. Now, let's deal with the assault first, sir.
Okay.
You were living in the house for a while, over a year.
Yes. Yes.
You were living in the house for over a year.
Yes.
And you paid no rent.
I was not, that wasn't the agreement.
Just a second. Just answer my questions. Did you pay any rent?
No, I wasn't asked to pay any rent.
Just a minute. There has to be a reason, sir, that you weren't asked to pay any rent. I'm asking you these questions because I have an objective. So you lived in the house for a year. Ultimately, you were asked to leave.
Yes.
And there was an altercation involving, yes. And the plaintiff, in addition to having the police there, filed for a protective order against you.
Yes.
And that case went before a judge.
Correct.
And you were present.
Yes. Went to court.
Did you have a trial?
Yes.
Did you testify?
Well,
He said yes or no. Did you testify?
no.
Did you consent to her having an order of protection?
I'm not aware of that. No.
Do you know whether she got an order of protection?
I was told, but I was never served. I was in jail. I was taken
You
to
were in jail
the
for
next
what?
for the assault.
Right. Do you have a copy of the protective order?
Yes.
May I see it, please? Okay, so the proceeding was not for an assault, it was for harassment. Is that right?
It was for both.
I don't see anything about an assault there.
Okay, there was 2 assaults. The first one was on August 29th. The second one was on November 11th. And when they arrested him the second time, the police officer told me to go file for another restraining order, limiting him more.
No, just a second. The complaint
It was August 29th.
was on August 29th.
Right.
That's it. Do you have photographs of your injuries as a result of that?
Yes.
I'd like to see them. How did she cut her arm, Mr. Simple?
They were coming at me, her and the Beverly girl, and I pushed them in an open hand, and she fell against a stereo.
Okay. How did you cut your hand?
Daniel pushed me after he pushed Beverly.
Okay, and what were you doing with him on that day?
Beverly and I confronted him about not paying anything since April and having his stuff all over my property. And I got a letter from code enforcement saying that they were going to fine me $500 a day if he didn't clean up the stuff from my yard. And we
Because he brought a whole bunch of stuff from your yard. Would
Yes.
you show me a photograph of your yard?
Oh, yes.
May I see it, please?
And there's another.
Who's mobile?
I'm sorry. That's the motorhome I stay in because the house needed to.
So you stay in the mobile home on the property?
Yes.
Well, whose bicycle is that?
All that stuff is Daniel's. Everything in the yard.
What about the...
everything.
You mean he got out of... Is that all your stuff?
That's material that I brought there to work on the house. That is my bicycle.
Well,
yes.
the lumber. I mean, he didn't get out of jail and they didn't give him lumber. They give you $1 to go on a bus. They don't give you stacks of lumber. So evidently he bought that, but he didn't use it inside the house.
Right.
You live in the trailer behind with a friend.
No,
is that right?
Myself. I lived in by myself.
You lived there by yourself?
Yes, in the motorhome, yes.
Yeah. When Daniel was in the house during that year that he was there and you were living in the motorhome, he was living in the house?
Yes.
Did you ever have dinner together?
No.
No?
Yes, we did.
Did you ever have dinner together?
Yes.
Did you ever have more than dinner?
No. Conversation? No.
Just conversation?
Conversation. I bought materials for the house to fix it up.
Yeah, well, it looks awful, and you wouldn't be living in a motorhome if you could live in the house. Okay. You pushed her, sir, and somebody, another judge, not a somebody, another person who has the same quantum of proof that I would have to if I heard this case, found that she was entitled to a protective order. And you're not allowed to put your hands on somebody. You're not allowed to do that.
I felt that I was
She has to be compensated then. Yeah. Now, do you drink?
On occasion.
Sometimes?
On occasion, sometimes, yes.
On occasion?
Yes.
More often than not?
No.
Okay. Now,
A year. I knew nothing about paying any rent.
when she told you to move out because you weren't doing your end of the bargain, how long did you stay in the house
I
after
left.
she told you to move out?
I left. I was arrested the next day. When they told me to move out, that's when
you
they
were
came
arrested,
at me and I
but
pushed them away.
That's August,
They
and then
were
you moved
telling
out.
me to get off the property.
Just a second. Just a second. They told you in August.
Mm-hmm.
Did you move out in August?
Yeah,
Did you move out in August? Did you ever come back?
occasionally. I would come back and try to get some of my stuff. I had a stay-away order, so I had to take a police officer over there to get my stuff. All my stuff that I bought for the house, the materials, supplies to fix the water leak in the house, is still there.
Well, a lot of that stuff is just junk.
No, this is brand new stuff, still
That's in
a
the
box.
backyard. No, a
No,
lot
that's
of the
not.
stuff that she just showed me was junk. Well, the bicycles look like junk.
Okay, that's...
I don't know whose they
That
belong
was
to.
something that was brought in there before I started getting the water leak fixed in the house.
Okay.
Damages, she said, was a drywall in the house, but it had a water leak and I had to fix. I bought the material to repair that.
All right. Ms. Cerati, let me explain something to you. I don't believe that he owes you any rent. Somebody that you knew, you made a ridiculous arrangement with him, but he does owe you for this assault. Other than this cut on your arm, because I don't think he has a right to put his hand. Did you receive any medical treatment
No.
for your injury?
No.
Okay. Who is living in the house now?
No one right now.
And you're not living in the trailer either.
No, I'm in the motorhome. I'm still in the motorhome.
You're in the motorhome.
Yes, because the house still needs fixed.
And where is your brother? Of course. Where is your brother?
My brother lives in L.A. right now, but he's coming out in a few months to live at the house.
Well, somebody better fix it up.
Yes.
Judge Judy continues in a moment. And later today,
You opened your car door. You weren't looking where you were going. Didn't even look. Didn't even look. Opened the car door. Didn't even look.
Cherie Zarate says ex-boyfriend Daniel Seipel owes for rent and utilities, property damage, and for injuries she suffered during an assault.
All right, I'm awarding you $1,500 for the injury that you sustained. He doesn't have the right to put his hands on you. Sir, where are you living now?
Where am I living? At my friend's house. My friend's house.
Do you pay rent?
No.
Good for you. Okay, we're done. Thank you very much.
All right, thank you, Your Honor.
This case is concluded. Parties are excused.
They were coming at me telling me to get off the property.
Really in myself.
That wasn't the agreement. I was never supposed to pay any rent.
He was just bringing junk and dumping it in my yard.
Well, she didn't want to hear anything that I'd bought, materials to fix the problem in the house.
I've been slowly fixing it myself.
I just got the materials to work and they said, get out.
I think he's a hoarder. He just collects things.
It was aggressive, yes.
Just harassment, and I didn't want to have to be calling the police every other day.
Not to do it again.
I'm just glad that he's finally out of my life.
And now, the next case.
All parties in the matter of Koska versus Zurati Step forward.
23-year-old Brittany Koska is suing fellow motorist 22-year-old Sabrina Zarate for damage to her car caused by an accident in a university parking lot.
Oh, my goodness. That is a familiar scenario. Okay. P, that would be you. It's pulling into a spot.
Correct.
When were you pulling into the parking spot?
It was on February 14th at 7:45 a.m.
Where were you going?
Cal Poly Pomona.
To school. And you?
School. Same school.
Okay. So you're pulling into the spot, and?
As I was pulling in, I was halfway into the parking spot when she swung her door open and hit my front bumper. As I got out of the car, she got out of the car and indicated she was sorry she didn't see me. The comment. So then I asked for her insurance information. She said she didn't find herself at fault and would like to discuss it with her father. She walked away from the scene. As I called the police, I texted her saying I called the cops.
Okay, then she came out.
Yeah.
Anyway, that's what it is. And she says, Ms. Zarate, you say, go ahead.
So, what her statement is actually incorrect, Your Honor.
No,
my
just
door was
tell
already
me. I'm
open.
listening to your
Okay.
story.
So my door was actually already ajar. It was partially open.
Show me how ajar with your hands. Look at
So this is my vehicle. I was about this open in my parking spot still. And she pulled, there's an empty spot next to me. She pulls in obviously in a hurry and she hits my car. She impacted it. So we get out of the car and I've never been in such a situation. So I ask, okay, what should we do? She's like, just give me your information.
Okay. I don't care about the information back and forth. So you say that your door was partially ajar. I'd like to see the damage to your car. Was there any damage to your car?
No. The door's steel. The bumper's plastic, so.
Well, if she were going fast, and what would have happened is, as you indicate,
Obviously going too fast.
Your door would have come off if she hit your car door.
It's kind of hard to see since the car is black, but it was scary.
Oh, pulling into a parking space, and you're being vigilant about what's around you.
Correct.
And you see the defendant's car.
Correct.
Did you see her in the car?
I did see her in the driver's side.
If you saw her in the car, you knew she was getting either in or out, right?
Right.
So you had a 50-50 shot whether she was getting in her car or out of the car.
No, that's incorrect because
Sure it
since
is.
we're at school.
She couldn't have been going up or down. She had to be going in or out.
Correct.
Or sideways.
Judge Judy continues in a moment.
Were you covered at the time for liability?
I didn't realize, but it was lapsed.
So the answer is you didn't have insurance.
Correct. It was lapsed.
You think you're going to get in the last word? If you'd had lapsed insurance, it means you didn't have insurance.
Correct.
Don't say it was lapsed again.
Real cases, real people. Judge Judy. Brittany Koska says fellow motorist Sabrina Zarate opened her car door just as she was pulling into a parking space next to her. She is suing for the cost to fix her vehicle.
Now, what you're supposed to do is, when I'm driving and I see a passenger, in a car, I'm saying to myself, are they going to get out of that car? So I'm going to slow down and be really vigilant until I pass them to see what they're doing. That's just common sense. Now, she was almost in that spot.
She actually wasn't, Your Honor.
Sure she was. She had to have been. You didn't say that that's not how the accident happened. You're not saying that that's not what...
My door was already open, Your Honor, and she pulled in.
Listen to me.
And she hit my
No.
parked car.
No, you keep saying that over and over again. What I'm telling you is that when you got out of the car, you weren't being vigilant enough.
I don't have eyes behind my head.
Oh, well, just a second. Well, you're supposed to. You're supposed to be able to look out.
Hurry, Your Honor. She was obviously in a hurry because she wouldn't have hit my car. Yeah. She didn't even want to exchange information because she was in such a hurry.
I think that you both weren't being terribly careful. Do you have insurance?
Yes, I do.
Were you covered at the time for liability?
I didn't realize, but Your Honor, it was lapsed.
So the answer is you didn't have insurance.
Correct. However, it wasn't my fault, so...
Just the answer is you didn't have insurance.
Correct. It was lapsed.
You think you're going to get in the last word? If you'd had... Don't say it was lapsed again. You didn't have it. I didn't say you never had it. You didn't have insurance.
Correct.
Do you have insurance?
Yes.
You have liability insurance.
Yes. I don't even think she's on the insurance because her name's not on the insurance card.
Name doesn't have to be on the insurance card.
Just want to make sure.
The car has to have insurance.
Correct.
Your car had no insurance. However, I do think that you were partially responsible for this accident. I think that you were probably not vigilant enough and not careful enough. So was she, because she got out of the car, and whether she kicked the car. What kind of car do you have, by the way?
I have a Honda.
When you say my door was partially open, when you usually partially open a door, it's because you're doing something. If you're getting out of a car door,
I was reaching
either
over to
get
get
out.
my belongings.
Oh, just a second.
And about to get
Hold
out.
on a second. So you were reaching over.
My
to the
door was already
passenger
open.
side. You were reaching over. No, I don't believe. If she hit your car that way, it would have taken your door off.
It wasn't all the way open. She hit the edge of it.
You're sealing it for yourself. You opened the door partially to let some air in the car. You turned off the car.
It was already off. Then I opened my door.
Oh, it's getting. You don't realize where you're going.
Judge Judy continues in a moment.
I want you to go step by step with me. You turned your car off.
I reached.
I don't want you to say my door was already open. It didn't
Okay, I
open
turned
by
my
itself.
car off.
You
I
turned
opened my
you-
door.
Slowly.
Closed captioning sponsored by. Are you the victim of a scam? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
Okay, so you turned your car off. I want you to go step by step with me. You turned your car off.
Turned my car off. I took my keys out of the ignition. I reached over to get my belongings. My door was already open.
No. I don't want you to say my door was already open. It didn't
Okay, I
open
turned
by
my
itself.
car off.
You
I
turned
opened my door.
You turned the car off.
Correct.
Step by step. You turned the car off.
Right. I set my keys down.
You set your keys down where?
On top of my purse. In my
On
purse.
top of your purse,
I
which was
opened
where?
my door.
On top of your purse, which was where?
On the passenger side.
Where your books were and your pocketbook, right?
Correct.
And then slowly, you took the key out of the ignition, you put it on top of your purse, you reached over to the side to get your stuff. And
I opened my door. I set my keys down in my purse, on top of my purse. I opened my door, and then I leaned down to get my books, and that's when she impacted my car.
No, didn't happen that way at all.
Okay.
No way. She's not telling me the truth. You have an estimate to fix your car?
I do.
That's not what happened.
Either way, she hit a parked car.
No. You opened your car door. You weren't looking where you were going. Got your things, took the keys out of the ignition. I believe that. Bent down to pick up your stuff. Believe that. Didn't even look. Didn't even look. Opened the car door. Didn't even look. That's what you did. Judgment for the plaintiff in the amount of $25.65. Thank you. That's all.
Why is our excuse? You may step out.
Judge Judy continues in a moment. And on the next Judge Judy. The landlord who never left.
You slept in the laundry room next door to his apartment. That's ridiculous. You're a scammer and a fraudster.
Next Judge Judy.
She had her sunglasses on, 7 a.m. in the morning.
Usually when it's sunny, I wear my sunglasses, so I don't know if that really causes somebody to be distracted or not. I could see if I didn't have my sunglasses on, maybe that would distract me.
She obviously was going really fast. She hit my car. Obviously, her car was damaged.
No, I was not. I'm pretty sure if I was, her door would be off.
She was going so fast, she was in a hurry. Of course,
She swung her door open, I hit it, and she said she was sorry because she knew it was her fault.
my door didn't come off. She hit the corner of it, so she just impacted her car.
Fortunately, she didn't have insurance, so it's illegal to drive without insurance, so I won the case.
It's simple that she hit my car, and I can't believe she's fighting it.
Have insurance.
An entrepreneur cashes out her company.
You sold that business to the defendants.
Correct.
For how much?
$800,000.
But
There are 3 things that they have signed off on that I have problems with.
did she mess
You went to mediation. You hired an attorney.
with their success?
What proof do you have that she libeled, slandered you, and caused you to lose business?
This is Judge Judy. Janie Furling is suing Russell and Juliet Slaybaugh for legal fees resulting from the sale of her business.
Judge, this is case number 21 on the calendar, the matter of Furling versus Slayball. Parties have been sworn in, Your Honor. You may be seated.
Ms. Furling, you had a T-shirt screening business?
Yes, silk screen printing.
And in 2017, according to your complaint, you sold that business to the defendants.
Correct.
Paid in 2017 the majority of the $800,000.
Yes, I was.
How much were you paid?
$720,000.
And when were you supposed to receive the other 80?
It was a 5-year note, and they had the first 2 years deferred with interest only, and payments were supposed to begin February 1st, 2019.
According to your complaint, for whatever reason, the defendants were in default of that $80,000, or part of it. And your contract with them provides that if you have to use any legal means in order to enforce that $80,000, that you would be entitled to legal fees. You acknowledge, Mr. and Mrs. Sayborg, that that's what the contract says.
Yes.
Mm-hmm. Your complaint is that you agreed to go to mediation. You went to mediation, you hired an attorney, you paid for the mediation, which was unsuccessful, at least in part because Mrs. Slaybog didn't show up.
That's correct.
So my first question, just a second. So my first question to you is, what was the date of the mediation?
January 8th.
Of what year?
2019.
Oh, 2020.
I'm sorry, 2020. I'm sorry, 2020.
Were you present?
No, I was not.
Do you have a document that shows me that you had given your husband your power of attorney on that date to mediate?
No, I don't have a document, no.
Were you hospitalized?
No, I had the flu, though. I was sick.
Do you have medical note to show me that you were sick?
No.
Then you have to pay her legal fees.
Ma'am,
then you have to pay her legal fees.
I am an officer of the corporation as well.
Is.
So we were essentially negotiating for the corporation.
No, you were both supposed to be there. Your wife said she had the flu. Did the matter go to mediation? Did you each testify?
We both went, both parties went to mediation, Your Honor,
No.
yes.
I did not testify.
Well, not all the parties went to mediation. Your wife didn't go, and she was a signatory to the contract.
That's true.
She was a signatory to the contract.
But the corporation essentially was the entity.
Well, you say the corporation went. Who signed the contract?
Both she and I
did.
as officers of the corporation.
Just a second. Hold on. No, this purchase and sale agreement was between the two of you, Russell and Juliet Slayball, or a corporation to be created but had not been created, so the only people that signed the contract were anybody signing it.
That was signed in December, I think in December of 2019. The corporation was...
2016.
16, sorry, yeah.
In December 28th, 2016.
Right, the corporation was formed December 20th of 2019, and all of the escrow, 2016. And all of the documents, all the escrow, everything is done in the corporate name thereafter.
I don't care. I don't care. What I have are the documents that indicate that you and your wife both signed the purchase-sale agreement. That's what I have.
Well, right,
That's all that I have.
Ma'am, I think that purchase
That's all that I have.
I think that purchase and sale agreement specifies that a note would be created. The note was ultimately created during the escrow process. And then there's terms within the note that specify kind of the way things went. So there was an offset provision in the note.
Would you tell me why your wife didn't show up to the mediation?
Because she didn't want to get everybody sick. I mean, she wasn't feeling well. She didn't want to get everybody sick. I mean, I guess, especially these days, we should appreciate that.
Did you call the plaintiff or the mediator that morning and say, my wife is sick? We have to postpone this mediation. Just answer my question. Did you call?
No, we did not.
Did you call?
No, we did not. Ma'am, in fact,
don't you think that that's a little outrageous?
I think, actually, I'd like to take a look at the mediation. I believe the mediation was called out in the corporate name. So there was a corporate representative.
Why don't you pay attention to my question? Mm-hmm. My question was, if your wife wasn't feeling well, civilized people put in a call to the mediator who was being paid and to opposing counsel or their opposition and say, My wife, who may or not be there as a witness, is not feeling well today. We're going to have to postpone.
We may have. We may have mentioned to the mediator. We saw it as a corporate matter, and we had officers of the corporation.
Okay. Now, do you have a separate matter pending for any of the balance of this $80,000?
I don't have any matter pending.
Do you?
No. A separate matter? Well, there are three things that they have signed off on that I have problems with, and before I can take them to court and actually sue them on these things, I had to agree to mediation. And so that's why we went to mediation first.
That's not true.
Just a second. So what you are telling me is that you do intend to sue them for whatever balance there is of that $80,000.
There is the possibility.
Is that what you're telling me?
Yes, there is the possibility of that, but I'm not sure yet. At the moment, if I did take them to court, I've been advised how much it would cost me to take them and the chances of collecting. I have a statute of limitations that I've been advised on, and so I still have time.
Ms. Furling, you have to understand that I am not entertaining your case unless I have a clear, unequivocal statement that you do not intend to pursue the balance of the purchase price, because in that proceeding, you will be entitled to counsel fees. So I need a clear, unequivocal statement that they are going to rely on, that you have no intention and you will not be filing a lawsuit against them.
At this time.
And it will be binding.
At this time, I do not have any plans.
Not at this time. Sorry. Doesn't work for me.
Right.
You have to say clearly, unequivocally, that you will not file a lawsuit for the balance of the purchase price, because in that lawsuit, pursuant to your contract, you would be able to seek counsel fees. I am not going to entertain your case unless you don't say to me at this time. You have to say to me, I will not file a lawsuit against the defendants for any part of the purchase price. This matter today will resolve all issues.
I do understand, but may I back up a little bit?
Okay,
This is not the first time that I have sought legal fees. We had a first set of lawyers when they first defaulted on the loan, and I had to hire a lawyer, and we did a lot of back and forth, and it came to a certain amount, and they paid for it. I'm entitled to be reimbursed for enforcement and collection.
Very good. I have to tell you, I'm not repeating myself again.
Well, I guess I will say so.
I'm not repeating myself.
Yes, I will not pursue it. I will not pursue the $80,000 that they owe me on the non-negotiable note in the future. And I would like legal fees to reimburse me.
Counsel fees.
I'm sorry?
Then you're entitled to counsel fees. What were your counsel fees for the mediation?
It came to, I have it written down, it was $4,000.
No,
You want me to get the exact agreement?
Yes, I want you to give me the exact. You're entitled to counsel fees.
Yes, I have it right here.
For the mediation.
I spent $2,500 for the lawyer.
I'd like to see proof of that, please.
There's the first check, which was $500. Would you like me to put in the second one?
Yes.
That's the second one for $2,000.
Okay, good. Next.
And then,
so that was for the lawyer.
Here's the invoice for $75.
That was for the mediation service?
That was for the mediation service, and here's the proof of payment was done on my credit card.
That comes to $48.75.
Yes.
Yeah, that's your judgment. Now, you have a counterclaim. Your counterclaim is for libel, slander. I see you have no witnesses. What proof do you have that she libeled, slandered you, and caused you to lose business?
Ma'am, we have several emails that she sent to customers, sales representatives, essentially people that were supporting.
No, just a second. Just a second. Well, I'd like to see copies of those emails. And then, of course, on the second part of your claim, that would be for libel or slander. The second part of your claim is that you lost business as a result of that.
Correct.
And then you would have to have a witness that says that they believed that, and therefore you lost business. So first, let's put down.
Sure.
First, let's put down on the screen the emails that she sent.
That's the first one.
That's not libelous.
Well,
next.
Judge Judy continues in a moment. And later today.
The contract that you had with the defendants is clear, and it's an enforceable contract.
But that wasn't the context of
that
the
is what
environment.
You mean? I don't understand what you mean.
Janie Furling claims Russell and Juliet Slaybaugh owe for legal fees after the couple defaulted on the purchase of her business. The defendants are countersuing for loss of business due to slander and defamation.
Now, you did, in fact, default on your loan.
No, ma'am, we did not. There's a provision in the note that was properly offset on August 22nd because we followed the letter of the note, sent a certified letter to Ms. Furling. There was never a detailed response according to the letter of the note. And so on August 22nd, it was offset.
Do you still have your business?
Yes.
Are you still running your business?
Yes.
Goodbye. Judgment for the plaintiff in the amount of $48.75. Thanks very much.
Thank you, Your Honor.
This case is concluded. You're excused.
I respect Judge Judy. She heard the evidence and she ruled the way she did, and I'm actually relieved it's over.
Well, I am pleased that I got reimbursed for my legal fees.
She called customers, all kinds of things like that.
I sold to the wrong people.
All parties in the matter of Isham versus Hughes, Dirksen, Hughes. Step to the podium.
Jessica Isham is suing James Hughes and his wife, Penelope, and vet bills.
Miss Isham, you purchased a kitten from the defendants. It was a Bengal kitten.
Correct, Your Honor.
They're very sweet animals. And you purchased the kitten from them on the 25th of March
Correct.
of this year. Is that correct?
Correct.
How much did you pay for the kitten?
$600.
And you found the ad where?
Online.
Do you have a written contract?
Yes, we have a
that
contract.
the defendants gave you? I'd
Yes.
like to see it.
Sure. Try not to bend it. That's it.
Okay, this is the contract that you had.
Correct.
To the best of my knowledge, the above kitten is in good condition and health with no congenital defects. The purchaser, that would be you, must take the kitten to a professional veterinarian within 72 hours. If this veterinarian finds the above kitten to be in poor health or to have a congenital defect, the purchaser must bring a signed statement for the veterinarian as to the problem within 72 hours of the purchase for a full refund. Breeder will not be responsible for any veterinary bills. After 72 hours, all sales are final, except for congenital defects, which are guaranteed for 1 year with written confirmation from a professional veterinarian.
Correct.
So this is what happened within 72 hours. That's clear
Because of COVID.
from your statement. Whatever the reason, when you purchased the kitten, the country was already in the midst of the pandemic, which according to you was one of the reasons you wanted the kitten.
Correct.
So you could have modified that contract when you signed it and said, if I can't get to a vet within 72 hours, can I have a week? But you didn't. You signed this contract. Several weeks later, you took the kitten to the vet. And according to you, the vet found that the kitten had suffered some sort of an infection, which required surgery. It was expensive. They also took blood from the kitten and found that the kitten had some sort of a feline COVID. And you ultimately, after a lot of money in vet bills, decided that the kitten could not be saved and you had her euthanized.
Correct.
That's what happened.
Correct.
And you believe that the defendants should be responsible for your veterinary bills as well as a refund for the kitten.
Correct.
I don't see that, Ms. Isham. You had a contract.
Yes, but I think because
You
of
had
the
a contract.
because of the context, and also because she wasn't just having FIP, she had FIV, ascites, several different illnesses that were from cat.
Well, what you indicate in your complaint is that the defendants never had a blood test of the kitten.
Correct.
A blood test is not a usual test that breeders have of either kittens or puppies before they sell them. At whatever age they sell them, they very often have their vet checked and or have vaccinations. But breeders don't have a blood draw. I've certainly bought enough dogs and cats to know that.
Judge Judy continues in a moment.
They didn't breach your contract. They didn't breach the contract for the sale
she had
of a
several
kitten.
verbal contracts with me, aside from the written one.
You cannot have a verbal contract once you have a written one.
Real cases, real people. Judge Judy. Jessica Isham claims James Hughes and his wife, Penelope Dirksen Hughes, sold her a sick cat. Jessica says the cat had to be put down after only 2 months.
Now, what I found more interesting from the defendant's side is you called them several weeks later and told them about your first visit to the vet.
Right.
And at that time, despite the fact that they were under no contractual obligation to you, they said to you, we will take him to the vet.
Because they sold me a sick cat. Because their environment is what induced her health issues.
You're not entitled to your vet bills, and you're not entitled to a refund for the kitten because you had a contract, and the contract was clear. Your obligation was to have the kitten vet checked within 72 hours. If, and I don't mean to make you feel guilty, but if you had done that, it is possible that the kitten would not have had the kind of infection that it did if, in fact, it was in a cat fight, as you suggest that it was, and the fur was covering over this wound. But the vet, if it had been checked weeks earlier, might have found it before it infected it badly.
It wasn't.
So,
I wasn't able.
Go ahead. You weren't able to because
I was not able to make an appointment because most of the vets were closed. I got an appointment quickly after I realized that she was lethargic.
But Miss Isham, that's not what your contract says. Your contract doesn't say that you have 72 hours after you notice some symptom of the kitten that you don't like. The contract that you had with the defendants is clear. It says your responsibility, if you want either a refund or a new kitten, your choice is to take the kitten to the vet within 72 hours of the purchase. You didn't do that. And it's an enforceable contract. I don't understand what you mean, context. There is no context in a contract.
Well, then why did they string me along? Like they were going to help me. Like they gave me information about FIP and where to get medicine, and they kept, we'll get back to you. Oh, we'll help you. Oh, this, oh, that. It really felt like
they were being nice people. They even offered you a new kitten. They're not responsible
for your vet bills. Why would I want another sick cat? Like, I don't...
I don't know why.
Judge Judy continues in a moment. Closed captioning sponsored by... Have you been cheated? Go to judgejudy.com, like us on Facebook, and follow us on Twitter.
They didn't breach your contract. They didn't breach the contract for the sale of a kitten.
She had several verbal contracts with me, aside from the written one.
You cannot have a verbal contract once you have a written one. That's the law. If you have a written contract, the only way you can modify that written contract is by another written contract. That's the only way you can do it. She did, in fact, say to you, in breach of that contract, but I feel sorry for you. I'll give you a new kitten if you like. She wasn't obligated to do that, which you could have had tested immediately, because what your complaint was initially was that the cat was lethargic because it had this infection. Breeders don't know where the infection... 25th, what was the date of your first appointment with the vet?
4/16.
So that was 3 weeks later.
I got the appointment on April 4th for the 16th. That's when I could get in.
Whatever it was, you had the kitten at home in your house for 3 weeks.
Because based on the conversation...
Sorry, Miss Isham, you don't have a case. Your case is dismissed. We're done. Thank you very much.
This case is concluded, and they step out.
Judge Judy continues in a moment. And on the next Judge Judy, a breakdown showdown.
As soon as we got on the freeway, the check engine light turned on.
You sold this car within a couple of months. Something doesn't smell right to me.
Judge Judy.
She was sick with more than 4 different illnesses.
I think she made the right decision. It was logical, reasoned, and informed.
That could not have occurred in that time frame that I had her.
It's very unfortunate, these things happen, but I don't think it's our fault.
Somebody's usually responsible for an accident.
A disputed path to their crash.
I was trying to get into this lane here.
But she was already in that lane.
No, I wasn't even in that lane.
I'm actually...
A crossroads.
He's 100% at fault when he hit my car.
Well, they only sent her 50%. She wants the whole thing. What do you think?
This is Judge Judy. Meredith Less is suing fellow motorist William Frankie for an accident on the road.
Judge, this is case number 42 on the calendar in the matter of Less versus Frankie. Parties are sworn in.
Miss Less, you had a car accident with the defendant over a year ago.
Correct.
You claimed that the accident was his fault. You did nothing about it for a year. Now you say that we have COVID, you had enough time to have your car fixed, so now you're pursuing a claim against him.
Correct.
That's where we're at. You were driving a 2009 Lincoln, and I assume you had liability insurance, but not collision.
Correct.
With whom were you insured?
Geico?
Do you still have the car?
Yes, I do.
And Mr. Frankie, what kind of a car were you driving on August 24th of 2019?
A Toyota Prius.
What year?
2012.
And did you have liability and or collision on the car?
Yes, I had full coverage.
Full?
Yeah.
With what company?
Kemper?
For my information, when you had this accident, did you exchange information with Miss Les? Did you give her your insurance card and your registration?
About the license and registration, but I definitely gave her my insurance.
You had never met Mr. Frankie before, is that right?
That's correct.
So if you had an accident that you allege was his fault and you decided not to call the police to the accident, I assume you were satisfied that you had sufficient contact information for him.
Correct. We exchanged all information.
So you had his insurance card.
Correct.
When did you notify his insurance company?
I contacted my insurance that day, and they started the process. And then I got in touch with Kemper within a few days, and they had me go through their process.
And what happened?
I submitted all the photos and information through the app they told me to download, and then that was it. And then I think within a month I got information regarding what the estimate for repairs would be.
Okay, did you get a check from his insurance company?
In July of this year, but I haven't done anything with it because...
What was the check that you got from Kemper Insurance?
It was 50% of the estimated repair costs.
Would you please tell me what was the amount of the check?
The amount was $715.43.
And when you accepted the check, full satisfaction of your claim?
No, I did not.
You had to, otherwise they're not going to send you a check.
Well, what happened was I took the car to a mechanic, and they called the insurance, and we're speaking with them, and they said they would send over a check. And then when I got the check, I called because it was for half the amount when they said they were going to pay 100% of the estimated repair cost.
Did you cash the check?
No. I have the check physically with me.
It?
Yes.
Great. Take it out. Great. Okay, very good. I'm actually liking this case. So you have an estimate.
I do.
To fix your car.
Through Kemper,
I'd like
yes.
to take a look at it because, Mr. Frankie, if your insurance company sent her a check, they found that you were at fault. Your insurance company found you were at fault. You understand that?
Correct, 50%. From my understanding.
Well, they only sent her 50%. Your understanding from what she says is she got 50%. Your insurance company found you were sufficiently at fault to send her a check.
Yeah.
Okay. You're going to tell me about the accident in a second. Would you just put up on my evidence screen the estimate of having the car fixed?
Yes, I already did.
$1,430. Okay, great. Now would you show me the damage?
Here's the first one. It's the right passenger side above the wheel fender area.
Mm-hmm. Now, you have a check. So the estimate is for $1,430.
Correct.
To fix it. You got a check for them for $715. Can you tell me why you're suing him for $1,430?
Well, I'm suing him for the full amount because he's 100% at fault when he hit my car.
Yeah, but you already have a check for half.
Okay, so when I spoke with my insurance adjuster, he said you either accept the check they sent or you take Mr. Williams to court. So I haven't done anything with the check. I'm not going to because I'm here today.
Okay, so you have that check.
Correct.
You have that check. Take it back and put it on your desk. Now, who was making a left turn? Were you both preparing to make a left turn?
No.
I was preparing to make a left turn.
Okay, and was Miss Les in front or behind you?
She came from behind me.
All right, Miss Les, you're driving down, you're driving in the same direction. You're in the left lane, he's in the left lane. He was looking to make a left turn?
So I was in the middle lane on the street. He was in the lane to my right. And he was somewhat behind me, like we weren't head to head on. He decided to turn. He hit the front passenger side of my car.
I was going straight.
You were going straight, and he says you were making a left turn?
I was getting into the turn lane to make a left turn.
But she was in the middle.
Yeah,
You were on her right.
I was on her right, correct.
I'm trying to visualize
I have
this.
some pictures.
She's in the middle lane, you're on the right lane.
Correct.
Oh, I'd like to see them.
Yeah.
Thank you. Okay, great. Oh, that's better.
I'm the blue car.
I'm not following. You're both going in which
So-
direction? Point to the direction that
So
you're
we're
going. I
going-
see where her car is.
We're going this way.
In that direction.
Correct.
And
I had just
she
come...
is the orange.
Correct. So I just come from this direction on a street, and I took a left turn onto La Brea here. So I took a left turn.
Okay.
And I intended to go up here to take another left down here. And this,
Okay,
so
but
I wanted to get...
but she's in your space.
So, yes, I think she was... I assumed she was also intending to take a left turn on to Romaine from La Brea here. That's what I assumed, because I was trying to get into this turn lane here. And there's...
Right, but she was already in that lane.
So I did not see her in this lane. I thought that you had to, I think, turn lane, and I was going into this turn lane. I was going into this turn lane to get here.
I see that.
I hit her here because I'm assuming she was going to go straight through to take a left turn also.
She was going straight.
Correct.
No, she
But
says she
that's
was
what
going
she said,
straight. You were
yeah.
not making a left turn.
No, I wasn't even in
Is that
that
right?
lane.
She was in this turn lane. So
I was in the middle
you
lane.
want to show me where you were?
Sure, I would love
You
to.
want to show me where you were?
And I wouldn't be making a turn because I know I was heading to Los Feliz, where I'd be making a right onto Sunset. So,
okay,
there I am in the middle lane, going northbound.
And you're going straight.
Correct.
And he's all the way on your right.
Correct.
And he wanted to get over to make a left turn.
Correct.
I got it. Did you have any damage to your car, sir?
the damage was very minimal. I have a picture of my mirror, but it was very minimal. Do you want to see the picture?
Well, is the mirror what hit her car?
That's what I thought hit her car. I'm not sure. I think when I have pictures of her car and I see that her mirror, it looked like I hit her mirror and possibly her fender.
Okay.
But I was unsure if I hit the fender when I saw the damage.
Okay. Mr. Frankie, you know, it's an accident. Somebody's usually responsible for an accident. Sometimes it's both people's fault, but usually it's one person's fault. That looks to me, what I saw, that this accident was your fault. You were in the right lane trying to get over to the left lane, and you hit her car. Didn't cause a lot of damage to yours. It's an accident, right? You had insurance. Your insurance company copped out. Her damage was $1,400. They paid her $7,000. She wants the whole thing. What do you think?
I know that I was intending to go into, I'd already went this direction, the opposite direction, past Romaine to go to Willoughby, which is further down, if you want to look right here on the chart. So Romaine is up here. Willoughby is down here. There's a parking structure for Target off of Romaine over here that I intended to go to. And you can only get there from going to Romaine. You can't get there from the other direction. So I went down, made a U-turn on Willoughby, came back.
I understand exactly what you're saying to me, sir, but you were in the right lane going to the left lane.
Can I show you another picture then?
And you hit her.
Yes.
She didn't hit you.
Judge Judy continues in a moment.
I don't think anybody's driving in the parking area.
Sometimes you can in California.
Oh, this is true. You're right.
And later today.
What special thing about this pontoon boat motivated you to spend 3 times as much as you could have for cash?
Meredith Less says fellow motorist William Frankie merged into her lane and ran into her car.
Now, she didn't hit you. You hit her.
But there's a flaw in the other picture that she showed.
Okay, I'd like to see it.
So if you would bring up that picture that she showed, you can see, but I don't have her picture. But I do have this Google map right here, whichever you'd like to look at.
Those things.
This right here.
Well, let me see the Google map. They confuse me usually.
So right here, I can turn it so it's the same as the chart.
Okay, better.
Okay, so here's Romaine. We're going up here. This is the turn lane. You can see the arrow right there.
No, I understand that. Where was your car?
So do you see that?
Was your car in the right lane?
The parking spots right here, where you can park
Yes.
your car. So
Yes.
I was
Were there,
not.
is what you're
I
telling me
was-
there were parked cars there?
Yeah,
Were there cars parked
I
there?
parked there. I pulled off the road and parked there from.
For what?
And I have a picture showing where my car was parked right after that.
Well, you didn't get hit because your car hit her.
Yeah, so I parked right there. I was trying to
Right.
get into this turn lane, and
Well,
I don't think
are you-
anybody's
is
driving
what
in
you-
this parking area. Was what I'm saying. There's two other lanes here.
Well, sometimes you can in California because if there's no parking between certain times and certain times, a whole.
Oh, this is
there
true. You're right.
Streets. There are streets where you're not allowed to park at all during certain times, and there's free-flowing traffic there.
Actually,
so my
you're
question
right. Yes,
is,
and it was at 7 o'clock, which is a rush hour.
so that would have been no parking in that area, as it is on Wilshire, for instance. You're not allowed to park after 4 o'clock on Wilshire in the park lane.
This is correct.
Mr. Frankie, I think that you owe the plaintiff $715, and then she's got the check from your insurance company. Now you're whole. Judgment for the plaintiff in the amount of $715. We're done.
Thank you.
This case is concluded. Parties are excused.
She makes the final call.
She looked to the evidence and saw the truth in what transpired that day.
I came in here just trusting that justice would prevail, and I kind of trust the final call.
He stated he was fiddling with the GPS.
Accidents happen.
Trying to get the car fixed.
All parties in the please.
Hamid and Susan Vasugi are suing William Hill for the cost of a pontoon boat, a boat motor, and registration fees.
Mr. and Mrs. Versugi, you purchased what you call a party boat.
Yes.
From the defendant, spent a lot of money not only for the boat, but for parts for it, for furniture for it, and now claim that you can't register it because of certain problems with the defendant's registration, and that you ordered a motor for the boat from him, gave him money for the motor for the boat, which he has not put in to the boat.
Yeah,
Correct. Suing for $5,000. I have a couple of questions. Do you have a photograph of this boat that you purchased from the defendant?
Yes, I do.
I'd like to take a look at it. Are those pontoons on either side?
Yes.
So it's a pontoon boat?
Yes.
And this pontoon boat is 30 years old, according to your complaint?
Yes, it's a 1989.
And how much do you claim that you paid the defendant for it?
$6,500 cash and $547 DMV fees.
You paid him, according to you, $6,500 in cash. Now, my question to you, Ms. Vasugi, before we go any further is, why would you pay him $6,500 literate on the internet, as I am? And you can go on the internet and you can buy a 1989 pontoon boat for anywhere from $2,500 to $5,500. And I have owned a pontoon boat. So I would like you to tell me what special thing about this pontoon boat motivated you to spend 3 times as much as you could have for cash than you could have any place else where I'm looking on the internet.
The body of the boat is in good condition, the pontoons and the body.
Yes.
We were going to replace all the furniture, and we wanted to fix the current motor, but we changed our mind. We thought it was a good value. We have some boating experience.
Just a second. You know, Mrs. Vasugi, I'm not buying that.
Judge Judy continues in a moment.
So far you've spent $16,000 on a boat with no proof that the money went to him when you could have bought a 31-year-old boat for $5,000.
Real cases, real people. Judge Judy. Hamid and Susan Vasugi claim William Hill sold them a pontoon boat with no title or registration.
Okay, now after you paid him, you invested a whole lot of other money in it. Tell me what other money you invested in the boat, because I need that for my record.
Sure. We bought some furniture for the boat. This is patio furniture.
I have that here. And how much did you pay? Just a second. And how much did you pay for the furniture?
It was $3,260.
So far, you're up to almost $10,000.
Yes.
For this 30-year-old boat.
A bimini top.
What kind of work do you and your husband do?
We're retired. We sold a car.
I'd like you to show me.
To for the money to do this.
To whom?
To an individual who paid us cash. I have the bill of receipt.
Does it have his name on it and his phone number?
It has his name.
Well, get me his name and his phone number. I'd like to know exactly how much this person paid you for your boat.
For our vehicle. No, this was for our
car.
vehicle.
He says he paid you. Just a second. It says he paid Mr. Klein, who I could call. I'm sure you have his number because there's an address there.
Yes, we do. We do.
It says he paid $8,000 in May of 2020. Well, the date has changed on that bill of sale to, it was something else before.
Yes.
Somebody tried to write May 18th.
And I have his phone number if you'd like to call him. But we sold him $8,000 in cash, and that's what we used to purchase the boat.
That's not what you say in your complaint, madam.
Well, we considered
you said you decided to sell. No. In your complaint, you say, we decided to sell our speedboat and buy a patio boat to cruise around. So far, you've spent $10,000
we didn't
on a
sell
boat
the
that you
speedboat.
could buy.
We still have it.
No, so far, just a second. So far, Ms. Vasugi, you've spent $10,000, and that's before the motor that you said you
Yes.
bought from him. You spent $10,000 on new furniture, $6,500 for a boat that you could have bought for $3,500. So we're up to almost $10,000, and then you decided to invest in a motor. And how much money did you give him for the motor?
$6,100.
And do you have a check for that cleared?
Yes.
And I'd like to see.
It's not actually a check. We took cash from the bank for $6,000, and then we had $1,000 out of our pocket. Or 100 out of our pocket.
Ms. Vasugi, so far you've spent $16,000 on a boat with no proof that the money went to him when you could have bought a 31-year-old boat for $5,000.
Judge Judy continues in a moment. Closed captioning sponsored by Scam. Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
All right, so I'm going to tell you this, Ms. Vasugi. I may be a skeptic, but I'm dismissing your case without prejudice. You go back to your local small claims court, and if they buy your evidence, good for you. I don't.
I mean,
do you understand?
I don't understand because I have proof of everything I spent. He gave me stickers that don't even belong to my boat.
What I'm telling you is neither you nor your husband look like foolish people. I don't believe in your cash transactions that amount to over $10,000.
They do cost that much, Your Honor.
Just a second. They may, and someone may believe you. I don't. You're no worse for your arrival here. You go back to your local small claims court and convince a judge, just like me. So I'm dismissing your case without prejudice because I don't buy it. Got it?
Okay.
Well, we have it.
Thank you.
This case is concluded. Parties are excused.
And on the next Judge Judy.
The boat was worth that much money.
I was happy with the decision.
We never got a title or registration. We were given invalid stickers.